In the 1997 case on that 14th Amendment issue, it was the Supreme Court said that what that last section in each amendment means. That was talking about the 14th Amendment, and I would say the same standard holds true for the parallel section in the 15th Amendment. They said, what is appropriate legislation? They said there are two things to keep in mind. One is that this is not the power of Congress to make new rights. It's merely to enforce the rights that are already in the Constitution. And whatever legislation they take, they must engage in formal fact-finding to find out what the violations are. And then they have to pass legislation that is both congruent and proportional to these violations of rights that the states are doing. But then the other thing they said that everyone loses sight of is that they said, however, it is up to the judiciary to say what is or is not a violation of those rights. Once the courts say rights are being violated, Congress can pass legislation to enforce it, but Congress cannot say, like in this case, that voter ID is a violation of 15th Amendment rights on the basis of race. Only the courts can say that. And then once the courts identify violations, Congress can pass laws to address it. If the courts say that something is not a violation, then Congress has no authority to pass a law that would outlaw it. That is what is going on with the John Lewis Act, is that they're saying that all of these common sense measures are violations of voting rights. Only the courts can say it, and the Supreme Court has